This is the last part of our video lecture series on the topic of disposition of property by testamentary succession, that is by wills. Firstly, regarding revocation of will by testator. Testator means a person who makes a will. Normally, the execution of subsequent will is a mode of revocation of all earlier wills. But it is essential that in case of such subsequent or last will, it is necessary to mention in that will, in a separate clause, it is necessary to mention that by this last will, the testator is revoking, hereby revoking all his previous wills, if any. But suppose the previously executed will is valid, but the subsequent will is invalid, then that subsequent invalid will cannot revoke previous valid will. Validity of the will basically depends upon its proper execution and attestation. Regarding registration of wills, wills do not require compulsory registration. Registration of will is optional, and even if it is registered, it is to be registered, then no any stamp duty is required. Even though testator is bequeathing through his will any immovable property like land, building, then also registration of such will is not compulsory. And on this aspect, it shows that disposing immovable property through a will, it shows the advantage of disposing such property by will as compared to transfer of such property by making gift deeds of any immovable property. For the purpose of transfer of immovable property by gift deed, it requires compulsory registration, and it attracts also very heavy stamp duty. The genuineness of will cannot be doubted simply because it has not been registered. But then also, when the testator himself registers his will, then such a registration of will raises a strong presumption of the validity of such will. So it is better to register the will. What kind of properties can be disposed through the will? So, while thinking about making up a will, firstly, testator must know or realize that what are his absolute properties. Which are his absolute properties? Means of which he is absolute owner. The property of which he is absolute owner, only that property can be disposed of by him. Such property may be movable property or immovable property. Immovable property may include land and buildings. If he is disposing immovable property, then exact and correct description of that immovable property needs to be mentioned in the will The description of property includes its identity, location, area, its boundaries, nature of holdings. His movable property may include various goods or articles, valuable goods like jewelry, furniture, car. So, before making will, testator must have beforehand the list of all such items or things, that is properties, which he wishes to dispose of through his will. He may also have intangible properties, intangible. For example, he may have rights into any trademark, patent, copyright, etc. Such property he can also dispose of through his wills. Besides that, he may have property in the nature of debt, that is, some third person is owing some debt to the testator. Then that property in the nature of debt he can dispose of through his will. Besides that, he may be having some investments. For example, investments into shares or debentures of any company, mutual funds, fixed deposit into banks, various kinds of policies. So, the benefits, right to benefits from such investments, it is also property and he can dispose of it through wills. So for that purpose, all such intangible properties, concerning the intangible properties, he must have beforehand all those documents which shows title, ownership and interest or rights of such testator over such intangible property. Then regarding obtaining of the probate of will. Probate. What is probate? We have already seen it in previous lecture. Probate means the copy of will which is certified under the seal of competent court. Probate is the conclusive evidence about the due execution and validity of the will. So how to obtain probate of the will? When any will is made by any Hindu, Sikh, Buddhist, Jain or Parsi person within the local limits of the ordinary original civil jurisdiction of the Bombay High Court, then obtaining of probate is necessary for giving effect to the will. If such will is executed even outside the local limits of the ordinary original civil jurisdiction of the Bombay High Court, but if such will is relating to the immovable property which is situated within such jurisdiction of the Bombay High Court, then in that case obtaining of probate for giving effect to the will is necessary. Who can obtain such probate? Executor of will, if it is appointed by the testator himself, or otherwise any legatee under the will who is the beneficiary, he can also obtain probate of that will. For obtaining from whom we have to obtain the probate? By the competent court. Competent court means the court having jurisdiction to grant such probate. And for obtaining such probate, such executor or legatee, as the case may be, needs to make proper application to such competent court. And while such making application, such executor or the legatee is required to pay proper court fees. Court fees is necessary. Court fees. Such court fees are calculated on the basis of aggregate market values of the properties which are subject matter of the will. So, through will, which property testator is disposing, especially immovable property, the aggregate market value of those properties needs to be ascertained, and on that amount court fees required to be paid for obtaining the probate. Thus, in case of Maharashtra, for example, when such aggregate market value comes to be 10 lakh rupees or more, 10 lakhs rupees or more up to whatever maximum amount, then in Maharashtra presently maximum court fee is of rupees 75,000 only. Rupees 75,000 only. But here it is to be noted that the issue of obtaining of such probate would come into picture only after the death of the testator and not at the moment of execution of will itself. So when testator dies, he has made will. For giving effect to that will, we need probate. Therefore, after the death of the testator, we need one means who is a beneficiary under that will, that is legatee or executor of that will. He needs to obtain probate for giving effect to that will. So, here we have concluded our discussion on this topic of disposition of property by testamentary succession, that is law relating to wills. So we will in the next series of video lecture we will consider some another topic. Here it is my request to all of you, please see my videos on these topics. Please subscribe to my channel. Please share these video links to all your friends belonging to legal profession, especially to junior advocates. Thank you very much.